Okay, welcome back. This video is going to be about subject matter jurisdiction. I'm going to start off with federal question jurisdiction. This part is not going to take particularly long. Federal question jurisdiction. All right. First thing to keep in mind is Article 3 itself allows federal question jurisdiction as long as there's a federal ingredient in the case somewhere, whether it be a cause of action, whether it be a defense, whether it be an element of a claim or a defense. Whoever's phone keeps dinging, can you mute your phone, please? So whoever's the dingee, please stop dinging. Thank you. All right. For the statute itself, it's much more complicated, but I'm going to distill it down to its basic components. All right. With 1331 analysis, right, district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, and treaties of the United States. All right? Rising under jurisdiction. Article 3 is easy to show. If there's any federal issue anywhere in the case, the original action, then there's going to be constitutional jurisdiction. Put differently, the Constitution would not be violated by hearing the case. The scope of 1331 jurisdiction is narrower, and you got to jump through a couple hoops to get to arising under statutory jurisdiction. The first thing you do is the well-pleaded complaint rule. That's a filtering step. Well-pleaded complaint does not tell you if there's a federal question that satisfies 1331. It instead tells you where to look for a federal question. And the place you look under the well-pleaded complaint rule is in the cause of action in the plaintiff's complaint. That means you don't look in the defendant's answer. You don't look in the defendant's counterclaim. You don't look at any affirmative defense raised in the answer. You look in the cause of action in the plaintiff's complaint. Equally so, that means that if the plaintiff in the plaintiff's complaint includes language that anticipates the defendant's anticipated defense, you don't look at that either. Put differently, the only thing you look at is that language in the plaintiff's complaint that states their own cause of action. Those allegations that, if true, would entitle them to relief. All right? That's where you look. Now where we know where to look, now that we know where to look, we now move on to this step. Does the well-pleaded complaint contain a federal question? And there's two alternative ways of doing that. The first way is Justice Holmes' creation test. Justice Holmes asks, where did this cause of action come from? Who created it? What sovereign created it, right? Was it a state sovereign or a federal sovereign? If it's a matter of state common law, then the cause of action does not arise under federal law. If the cause of action was created by federal court as a matter of federal common law, or by the Congress as a matter of a federal statutory cause of action, then under the creation test, the sovereign that created the cause of action is federal. And then the case arises under federal law for purposes of 1331. This alternative is easily analyzed, right? If the cause of action is, say, 42 U.S.C. 1983, right, the Civil Rights Act, boom, there's your answer. The claim arises under federal law, U.S.C., United States Code. Congress makes those, right? On the other hand, P sues D and P's cause of action, like in the Motley case, P's cause of action was a contract breach, right? Mr. and Mrs. Motley sued the railroad saying, hey, you didn't honor your promise to give me lifetime passes. It's a breach of contract. Now, in their complaint, they also said, oh, by the way, railroad, you can't rely upon this congressional act from 1906 that says you don't have to honor the contract, because that wasn't the plaintiff's cause of action. What the Motleys did in their complaint is they had two things: a contract cause of action, and then language where they said the defendant railroad's anticipated defense wouldn't work. You see how that happens? How that works? In the first step, the well-pleaded complaint rule, we knock out the defendant's anticipated defense. We don't pay attention to it, even though it's federal, because it's not a cause of action. It's the plaintiff's looking to what the defendant's defense is going to be. And the filtering leaves us with nothing more than the plaintiff's cause of action, which was a breach of contract. And under then the Holmes creation test, that breach of contract was created by which sovereign? Common law judges of state courts. Under the creation test, the law was created by state sovereigns and therefore arose under state law and therefore didn't satisfy 1331. Now this leaves just one last one, which is the Grable gun test. Now again, let's be clear about what we're doing here, right? When we're at the Grable gun point, we're looking at the two alternative ways to ask whether the well-pleaded complaint states a federal question, right? We only get to Grable gun if we've gone through Holmes' test and concluded that Holmes doesn't find a federal question in the well-pleaded complaint. This is an alternative to the Holmes test. And it's one that's very unlikely, in my opinion, to be on the bar exam because it's a very standardish, somewhat elusive standard used by the courts. I will explain it very briefly. The Grable gun test comes up when the plaintiff's well-pleaded cause of action is a state law cause of action that contains a federal ingredient. So for example, in the case of Gunn versus Minton, plaintiff sued the defendant for state common law legal malpractice. Okay, who creates malpractice? State common law, right? State sovereign. Under the Holmes test, a state law claim for malpractice is created by state lawmakers and therefore was not created by federal lawmakers. No federal question. But in Grable gun, when you have a state law claim that has a federal ingredient, maybe there's a rising under jurisdiction for 1331. Now get back to the Gunn case. P sues D for attorney malpractice, state claim. But there was a federal ingredient that was part of that claim. What was the federal ingredient? A patent issue. P sued D, state malpractice claim, and the alleged breach of the lawyer's duty of competence towards the client was failure to raise a patent issue in a prior patent litigation. So in order for the plaintiff to prevail on his state law malpractice claim, it had to prove, as the case within the case, that the defendant lawyer failed to raise an important patent issue. So to decide the state law claim, we had to decide patent law issues as part of the state law claim. In that case, the Supreme Court said that although in some cases there could be 1331 jurisdiction, that in that particular case, standard was not met. And you look at the factors here. When a federal issue is necessarily raised, and the Gunn case, it was actually disputed. In fact, in the Gunn case, the only thing the parties were fighting over was whether or not the lawyer should have raised the patent issue. Was it substantial? The court said no. Substantiality requires that the federal issue be substantial and important to the federal system as a whole, and not just to the parties. This patent issue only mattered to the parties. It didn't matter to the broader federal system. And finally, this last requirement, capable of resolution in federal court without upsetting the apple cart, without opening the floodgates. This last factor is concerned with making sure that allowing federal question jurisdiction wouldn't lead to a rush of state law cases going into federal court under the guises of 1331 federal question jurisdiction. Now you see by going through this briefly that this is something that's probably unlikely to be tested on the bar exam. If it is tested, let me know. I'm not going to go into it further because I don't think it's worth further time. All right, now let's go into something that I think is more likely to be tested. There's some interesting issues there, and that's going to be diversity jurisdiction. First thing about diversity jurisdiction. It doesn't require an amount of controversy in the Constitution. The Constitution merely requires minimal diversity. Don't think that's going to be tested, though. What's going to be tested, and I have no doubt, is the scope of statutory diversity jurisdiction, section 1332. All right? First thing about 1332, 1332A rather, it requires complete diversity. Anybody on the side of the P has to be diverse from anybody on the side of the D. All right? So if California against California and Florida, we do not have complete diversity. All right? Can't have same state on both sides of the V. Here's another thing to watch out, exam tip. The amount in controversy has to exceed $75,000, and you don't get to count interest or costs. So if you get a fact pattern saying the AIC is $75K, well, if it's $75K right on the button, it's not met. It's got to exceed it. Here's another issue that might come up. Aggregation. P versus D for two different claims. One for $50,000 for a breach, and one for $50,000 for an unrelated negligence. Okay? What's the amount in controversy? $50,000 or $100,000? What's the amount in controversy? That's right, $100,000. Any single P can aggregate all of their amounts against any single D, as long as they're separate damages. All right? If P sues D for under different theories for the same money, that's not aggregation. That's instead alternative theories towards the same relief. So example, P sues D for fraud for $50K. P sues D in an additional claim for breach of warranty for $50K. It's just a different way of getting the same $50K, right? But using a breach of warranty claim instead of a fraud. That's not two $50,000 claims that add up to $100,000. Those are two different ways of trying to get the same $50,000. All right? To use aggregation, it's got to be separate reliefs from one P against one other D. And aggregation only works from one person, one P against one individual D. So suppose I sue plaintiff 1 for $50,000, and I sue defendant 1 for $50,000, then I sue defendant 2 for a separate $50,000. I can't add those up. Aggregation only works when it's one litigant adding together all their separate amounts they have against one other single defendant. Now there's some additional twists when it comes to supplemental jurisdiction. I'll come to that in a little bit. Let's spend a couple more minutes talking about controversy. Something you might be tested on, though I think it's unlikely, is the St. Paul Mercury test, SPM, which says that we treat the amount pleaded by the plaintiff as being okay if it's pleaded to be over $75,000, so long as that amount is pleaded in good faith, unless the court is certain that it can't go over $75,000. All right? So you might want to look for a fact pattern that goes something like this. P sues D, seeks $100,000 because the plaintiff's toe was stubbed, but no actual other damages were suffered, right? And you think, well, how can this person possibly get over $75,000? All right? If the court is certain, if the court is certain that the plaintiff can't go over $75,000, then the court will disregard the amount pleaded and conclude the amount in controversy is not met. Conversely, if it's possible for a reasonable jury to find in the plaintiff's favor for over $75,000, then the court will conclude the amount in controversy is met. So say P versus D for negligence, and the claim damages include hospital visit for about $20,000 and then another $80,000 in pain and suffering. Well, we really don't know if that pain and suffering are going to be worth an amount that pushes everything over $75,000. Okay? Here the court would probably say that, well, even though I, the judge, am not personally convinced the amount of controversy is going to exceed $75,000, I'm not certain that it's going to be $75,000 or less. And since it's possible for a reasonable juror to find for over $75,000, the amount of controversy is met. That's the St. Paul Mercury rule. Good faith, We accept if plead in good faith unless the court is certain that the amount of controversy will not exceed the statutory amount. All right. Now let's move briefly into the types of disputes that are possible under 1331. First, this one's easy, right? Citizens of different states, I already said that. You can have Cal versus Florida, but you can't have Cal versus Florida and California. That's the complete diversity rule. But a more fundamental question is, what does it mean to be a citizen of a different state? So let's define that briefly. A citizen of a state requires two things, both of which must exist in order to have a citizen of a state. The first is the litigant must be a U.S. citizen, and they must be domiciled in a state. All right? A U.S. citizen who's domiciled in a state. They don't have to live in that state at the time of litigation, but they have to have established domicile in a state and not re-established domicile somewhere else. How many domiciles do you have at any one time? One. All right. Well, first, U.S. citizen. All right. Suppose you have the President of France who sets up domicile in Miami. Is this person, he or she, a citizen of a state? President of France moves permanently to Florida, but is still a French citizen. Citizen of a state? Nope. This person is a citizen or subject of a foreign country. All right. Suppose you have a U.S. citizen. All right. Born here in Florida, then moves to France for the rest of his life. All right. Is that person a citizen of a state? Yes or no? They are not. That's a U.S. citizen who's domiciled outside of the country. We call such a person stateless. A person who is stateless, a U.S. citizen, not domiciled in the U.S., cannot sue and cannot be sued under 1332. All right? Or under 1332A. They can sue or be sued in federal court if there's a federal question or some other statutory basis, but not under 1332A. All right? So now we're going to talk about U.S. citizens who are domiciled in a state. You start off with your birth domicile, and then you get a new domicile when you reside in a different state with the intent to remain whatever. Now, I tell my JD students that, like, courts are split on the test for setting up a new domicile, and some look to the intent to remain indefinitely or permanently or for the time at least. And right now I'm just going to say, let's just go with the majority rule. All right? Because if they're going to test you on domicile, that's probably what they're going to be looking for. The majority rule is that you get a new domicile if you set up residence in the state, which means you're there physically. All right? And you have the intent to stay in that state indefinitely in an open-ended way. All right? All right? Now say I'm moving from Pennsylvania to accept my new job down in Florida. I get hired here at the school. This is going to be my life now. And I'm driving down to Florida. I get into a car wreck in Georgia, and I'm stuck there. Of what state am I a domiciliary? Pennsylvania or Florida? Pennsylvania. I have the intent to remain in Florida indefinitely, but guess what? I wasn't physically there yet, right? Now say I live in Pennsylvania, that's my domicile, and I accept a summer job in Florida, all right? I'm going to say, well, I'm going to stay there for the summer, then I'm going to go back home to Pennsylvania, all right? Where's my domicile? Pennsylvania, even though for that summer I'm living in Florida. I may reside in Florida over the summer, but my stay there is not indefinite. It's a definite stay. There's a definite time by which I will be leaving. All right? So think indefinitely means open-ended. So domicile might come up in a whole variety of fact patterns and contexts in the bar exam. So this is something you really want to pay attention to. You really want to, because domicile is relevant to this, right? Diversity. It's relevant to personal jurisdiction, because domicile is a basis for personal jurisdiction over a natural person, right? It's relevant to venue, because it can be used to determine residence for venue purposes. So this domicile thing, oh, it's gonna be tested. It's just where it's going to be tested, on what subject. You know, is it going to be venue, is it going to be PJ, SMJ, I don't know, but it's going to be tested. If it's not on the bar exam, you come and tell me, because I'll be really surprised. But I think it's going to be tested. So know this, own it. Let's see what's next. All right, going back to the statute, and let's see how we're doing on the time. We started at 5:30, right? 3:16. No, I mean, we started at 2:30. Guys, I've been teaching since 9 a.m. this morning nonstop. I don't even know my name at this point. All right. I know, I can see it. You know, at first I saw a lot of and then I got a rush of energy, and I can see you guys feeding off the energy. So that the room is lightening. You know, lightening up, you know, energy, good buzz. And I'm sure sometime about 2.5 hours into this, I'm gonna start being like this. So at that point, you know, I need you guys to like start throwing pizza crusts at me or something and wake me up. All right. Was it, that is consent. Was that you, Britt? Yeah. Yeah, that's consent. That's a flat-out invitation recorded on the video camera. All right. You might be testing on subsections 2 or 3 because they're tricky. So let me go over them real quick. I'm going to do it in kind of a quick fashion. To teach it really well, I'd probably have to take about like 10 minutes. And I want to make sure we have lots of time. So I'm going to give you a quicker approach, but then you can go back and watch it on the video. And FYI, you go on my YouTube channel, I go over this stuff very slowly and very carefully. In my YouTube channel. It's one of my kind of like Khan Academy style videos, the black background and the chalkboard and the color, and I voice over it. So look for it in my subject matter jurisdiction section on the site. Let's go over it real quick. Number two is alienage jurisdiction. Darn it. Here we go. Alienage jurisdiction. All right, so you need at least a citizen of the state on one side, and on the other side you have a foreigner, okay? Well, that first clause that's in yellow highlight, that's the grant of jurisdiction. If that isn't met, then number 2, 1332A2 is not met at all, and you're just done, right? But if that's met, then there's a grant of jurisdiction, but there's further analysis, because the rest of this except that clause, is a divesting exception, which means if the conditions here are all met, then the grant of jurisdiction in the yellow is taken away. And what it's looking for is, what if you have a foreigner who has a green card, okay? They're lawfully admitted for permanent residence, okay? And they're domiciled in the same state as an opposing party. Now, if you take a moment to think about the policy behind this, then the statutory language itself is super easy to decipher. Okay? P, citizen of California, versus D, citizen of Germany, okay, who's a lawful permanent resident, means they got their green card, and they are domiciled in California. All right? Technically, this falls in the yellow. Citizen of a state versus a citizen of a foreign state, right? There's a grant of jurisdiction. The problem is the German defendant is, for all practical matters, their life is now in California. Why do we need diversity jurisdiction, which exists to prevent prejudice against out-of-staters, right? Why do we need diversity jurisdiction if P and D effectively are both tied to and rooted to the same state? And that's how that language works, all right? So if the foreigner is domiciled in the same state and they got the green card, then no alienage jurisdiction. But note the statutory language. It's not enough that the foreigner is domiciled in the same state as the citizen of the state. It's not enough that they've got a green card. Both these conditions have to be met because of that magical word "and," right? here's what you do. You take what I just said, go back to the statute. If you're still confused, look up my video. And if you're still confused after that, never hesitate to contact me. You know how to contact me. You have my email. It's in the system. Or you find it on the website or the internet. Let's see. This one over here, number 3, 1332A3. This is a super duper fun one. And it's best explained again by getting back to basics. All right, the Constitution itself permits suits between citizens of different states. That's regular diversity jurisdiction. The Constitution would authorize alienage jurisdiction. All right. Claims between a citizen of a state and citizens or subjects of a foreign state. So this last clause here is alienage jurisdiction. So California can sue somebody who's, just a citizen of France, right? California can be against Florida, that's fine. What about Germany versus Florida? There's nothing in the Constitution that permits one foreigner to sue another foreigner. There's nothing there that permits that. Unless there's a basis, say like, a federal question, right, jurisdiction. But if you're looking for diversity for foreigner to sue a foreigner, there's nothing in there that permits that. Well, this is where 1332A3 comes in, and I think it's just super neat. A suit between citizens of different states in which citizens or subjects of a foreign state are additional parties. So again, there's 2 requirements here. One a prerequisite, and the other the neat part. Citizens of different states. That's just like 1332A1, right? Suits between citizens of different states. What A3 adds is that once you meet the threshold condition of having a suit between Florida and California, you can then add on foreigners on both sides. So let me illustrate. I actually have it there from the last time I taught. Here we go. Okay, it's Florida and California and Germany and France. You see that? Florida versus California is okay under 1332A1, citizens of different states. Florida versus France is okay under Section A2, alienage jurisdiction, right? Citizen of a state, foreign state. That's okay. And this one as well, Germany versus California. Again, citizen of a state versus a citizen of a foreign state. Here's where A3 comes in. Germany versus France. That's okay, because we have a dispute between citizens of different states, that's up top, to which are joined citizens of foreign states as additional parties. That's the statutory basis that allows Germany, a German citizen, to sue a French citizen. All right? Now, what happens if I take out, this is going to be so much fun. Now it's like this. Florida and Germany versus France. Got that? This is okay as 1332A2 alienage. However, this is not okay at all. It's not permitted by the statute. Go back to the statute. To have this, Germany, whoops, I didn't mean to erase that. To have Germany versus France, you need, as a threshold, prerequisite, you first need to have a suit between citizens of different states. Does this scenario have a claim between citizens of different states? It's missing, right? Totally testable. Totally testable. Depends on just how evil the folks at the MBE are feeling that day, right? I bet if they test on that almost everybody's going to get it wrong. And I think everybody in this room can get it right. All right, let's move on. Let's see. Next, ice cream. Is anybody in the mood for ice cream? Mm-hmm. What does ice cream mean we're going to? Supplemental, that's right. Supplemental jurisdiction. Why supplemental jurisdiction is like an ice cream cone with sprinkles, okay? Here's our ice cream cone. Thank you very much, Patrick. If a federal court is like the cone itself, right, the receptacle into which a lawsuit goes, and the ice cream would be the claims, the suit itself, right? then what I'm doing is analogizing an ice cream cone to the court and the subject matter jurisdiction of that court, right? Now, the main idea of supplemental jurisdiction is it's like sprinkles, right? Original jurisdiction is the ice cream. You can't have a civil action in federal court without original jurisdiction, which means you need the court, the cone, and the ice cream, which is the original jurisdiction. And indeed, we know that original jurisdiction can come in many flavors. You could have 1331 federal question. You could have 1332 diversity. You could have 1335 statutory interpleader. You could have 1338 patents, copyrights, trademarks, and plant variety protection. I could go on, and I will not. Supplemental jurisdiction, though. You can't have supplemental jurisdiction unless you've already got original jurisdiction. Remember what the statute says. In any civil action on which the district courts have original jurisdiction, then there can be supplemental jurisdiction. Put differently, the threshold requirement before you can have supplemental jurisdiction is that you must first have original jurisdiction. Equally so, unless you want to be totally gross, you can't have sprinkles unless you first have ice cream to put them onto. That's a very fundamental idea and a very important idea about how supplemental works. And once we keep that idea in mind, then the other parts of the statute become very clear very quickly. Let's look at them. All right. Our first, well, okay, there we go. There's 4 sections to the statute, and each of them boil down to a very simple idea. Subsection A is a grant of supplemental jurisdiction. Subsection B does not grant jurisdiction, it takes away. It divests the grant of jurisdiction from A in certain circumstances. C allows the court to have the discretion to decline to exercise supplemental jurisdiction in certain scenarios. In other words, permits the court to punt away the supplemental jurisdiction that it might otherwise have. And D is a savings clause. What it does is that if there's a dismissal of supplemental claims, then the claimant will have at least 30 days to refile in state court without losing under the statute of limitations, assuming that the supplemental claim was timely filed in the federal court to start with. All right, I am going to focus on the 2 testable parts. Beyond this, C and D, I have nothing to say. Read the statute. It's good for you. But the ones I'm going to talk about now are A and B. All right, A, the grant. Here's your first thing. Got to have original jurisdiction. No ice cream, no sprinkles. Second thing is that once you have OJ, original jurisdiction, the court then will have a grant of supplemental jurisdiction if there's a sufficient nexus between the original claim and a supplemental claim. As the statute puts it, the original supplemental claim must be so related that they form the same case or controversy under Article 3 of the U.S. Constitution. More commonly put in the cases, it's got to be the same C, N, O, F. As the Gibbs case put it, you need a common nucleus of operative fact between the claim having original jurisdiction and any supplemental claim. All right? CNOF is going to be kind of similar to the idea of same transaction or occurrence that you studied in the joiner rules for a compulsory counterclaim. But it's probably the case, the scope of transaction or occurrence is not as broad as CNOF. CNOF may be broader. What are you going to look for? You would look for similarity in timing, similarity in legal issues, similarity in facts or overlap in facts and evidence, overlap or closeness temporally. The same kind of considerations you keep in mind if you were doing a transaction or occurrence analysis, right? So for example, say P sues D for, here's an easy one. P sues D for a federal civil rights violation for the defendant being a police officer who beats up the plaintiff, okay? Plaintiff has been beat up by a cop and does a 1983 claim under federal law. Plaintiff joins to that claim, to that lawsuit, a second claim arising under state civil rights law, asserting the same facts, but now the basis for relief is not federal law, it's state law. Let's say it's a Florida plaintiff and a Florida defendant, right? No diversity. Well, you'd have original jurisdiction over the federal question, federal civil rights claim, and you wouldn't have original over the state civil rights claim because the parties aren't diverse, but A would grant supplemental jurisdiction over the state civil rights claim because of the common nucleus of operative fact between the federal question claim and the state law claim. And supplemental jurisdiction can include claims that involve the joinder of additional parties. So say Florida sues, say, a police officer under a 1983 claim, all right, that is a federal question, and sues the police department and for some reason decides to use state civil rights law, all right? You see that? Well, in that case, we'd have original jurisdiction over the top claim because it's a federal question. We would lack it under the police department claim, and I'm assuming, so I should make it clear, that both are citizens of Florida. All right? So, 1331, federal question up top. On the bottom, we lack original jurisdiction, but it sure seems like the claim against the police department would arise from a common nucleus of operative fact between the two claims, and therefore 1367A would grant supplemental jurisdiction over the claim against the police department, and that's okay because you can use supplemental jurisdiction to assert supplemental claims that involve the joinder or intervention of additional parties. All right? Well, that is a good start for our analysis, but it is not the end of our analysis because A grants, but B can taketh away. Put differently, B, when triggered, might divest the grant of supplemental jurisdiction that's granted by A. All right. B looks to a number of things. I'm going to focus on the biggest things that I think that are likely to come up. The first thing you need to ask yourself is, under B, is what is the basis of original jurisdiction? Because B is only going to be triggered if the sole basis for original jurisdiction is diversity jurisdiction. And as it says, in a civil action in which the courts have original jurisdiction founded solely on 1332, all right, then there might not be supplemental jurisdiction. So when you're doing 1367 analysis, once you determine that there's the same CNOF, now move on. What's the basis for original jurisdiction? Is it a federal question? If it is, then B doesn't matter. Is it diversity and original jurisdiction? Then you're okay, because diversity is not the sole basis for original jurisdiction. Okay? But what if the sole basis for original jurisdiction is diversity? Okay? So let me give you an example. Let's make it Florida versus California. Let me think for a second. Yeah, we're good. Okay, Florida versus California for an insurance claim of $100,000 and a second claim against a separate insurance company for $10,000. Okay, you see that? Is there original jurisdiction over Florida versus California for $100,000? What kind? Diversity. So we have OJ here under 1332. Are there any other basis for original jurisdiction besides diversity? Federal question?
No.
No, I said it was an insurance claim, right? That's just a state breach of contract, essentially. No copyright, no patent, no statutory interpleader, just regular old diversity. All right. Obviously, no diversity jurisdiction down here. The amount of controversy is too low. And remember with aggregation, we can't add these babies together because it's not 1P versus 1D, it's 1P versus 2Ds. So we have 100K AIC and a 10K AIC. So down here, we have no 1332. All right, let's go on to 1367. 1367A. Let's assume that P is suing D1 and D2 based on insurance claims arising from the same accident. All right? Say, for example, there is an accident and the limit of the insurance policy against D1 is $100,000, but the plaintiff wants the remaining $10,000 of injury. All right? Or perhaps they cover different aspects of the injury. $100,000 for personal injuries against one insurer and $10,000 for property damages against the second insurer. Okay? Well, it would appear that these claims all arise from the same incident. Say, for example, it's a car wreck, right? My body is hurt badly and I need personal injury coverage from this insurance company, and my car suffers some damage, but not nearly as much, right? $10,000, all right? Sounds like a common nucleus of operative fact, doesn't it? In that case, 1367A would grant supplemental jurisdiction involving the joiner of the additional second defendant, right? But now we get to B. Now, first of all, what's the basis for original jurisdiction? It's solely 1332, right? So now we're square-faced with a possible divestment scenario. So now we're fully going to 1367B. So, and let me clean up my statute a little bit. There we go. Good. The first step is to ask, is OJ solely based on diversity? If so, continue. Then you have to ask about what kind of joiner scenario the supplemental claim is. Okay? And we have three laundry lists here. 1. Claims by P's against person joined under 14, 19, 20, or Rule 24. Or claims, this should be number 2, claims by persons proposed to be joined as Rule 19 plaintiffs. Or 3, seeking to intervene as plaintiffs under Rule 24. All right? So now it sounds pretty complex, doesn't it? Like, holy crap, I need to do all this joiner stuff. And if time remains later in our review, I'll go over some of the joiner rules, but I'm not sure we'll have time to do all that. I'm going to do even better than that. I'm going to give you a shortcut. Not a shortcut, but a hint that may knock out a lot of the need for further analysis. Question: what is common about the claims of number 1, number 2, and number 3? Plaintiffs. All these joiner scenarios where you might knock out supplemental jurisdiction involve claims by certain types of plaintiffs, right? Put differently, if the supplemental claim is asserted by someone who's not an actual plaintiff, I don't mean a third-party plaintiff, I'm talking about real plaintiffs, people that are on the left-hand side, right, of the V. If the supplemental claim is by a plaintiff, we'll have to continue. But if the supplemental claim is by somebody who's not in that P position, on the left-hand side of the V, you're good. How's that for simplifying things? In your mind, the first things you need to think about. Yeah. Solely diversity? Oh, yeah. Claim by a plaintiff? Supplemental claim by a plaintiff? No. Okay, you're good. Right? Pretty cool. Now, suppose the supplemental claim is by a plaintiff like it is here, right? Supplemental claim of Florida versus Cal 2, all right, on the bottom. That means we got to continue, right? So now we know it's a claim by a plaintiff, but against what? Now we have to ask what kind of defendant this is. What joiner rule was used to join the second defendant? Rule 13, 14, 19, 20, 22, 23, 24? Which one? Any guesses? 19? No. No. You know why? Because P could sue Cal 2 separately and still get that $10,000. Very unlikely to be a Rule 19 defendant. So I'd say no. But you're very close. Try again.
20?
What's that?
20?
Yeah, 20. This is permissive joinder of defendants under Rule 20A2. All right? Because the claims against them arise out of the same transaction, occurrence, or series of transactions or occurrences, right? And involve at least one common question of law or fact, right? Same car accident led to the personal and property losses. So what we have here is a claim by a plaintiff against a Rule 20 defendant. Now we go back to the statute. See, to know supplemental, you got to know your joinder rules. And if you know your joinder rules, then you're going to do much better with supplemental. Okay, obviously, number 2 doesn't apply. Claims by persons proposed to be joined as plaintiffs under Rule 19. This plaintiff wasn't asked to be joined under Rule 19, wasn't forced in. That was the original plaintiff. It's not a Rule 19 plaintiff. And intervention is not involved in this fact pattern at all, right? Rule 24. Instead, we have a claim by a plaintiff against a person made parties under Rule, boom, Rule 20. 1367B. Does it divest supplemental jurisdiction? Yes or no? Yes? Yes. 1367B divests because original jurisdiction solely diversity, and it's a claim by a plaintiff against somebody joined under Rule 20. Okay? So you keep these principles in mind under B. What bases do we have for original? If it includes federal question, don't worry about B. If the sole basis is diversity, worry about B. Is the claim, supplemental claim, by a plaintiff? If not, don't worry about it. B doesn't divest. If it is, then you need to continue and consider the joinder scenario extremely carefully. All right. Was it that hard? Was it easier than this or harder than this when you studied it in your first year? It was harder, right? Because all the stuff was new. Think about how much you've internalized as attorneys, or soon-to-be attorneys, in the several years since then. All right, let's spend a few minutes talking about federal question jurisdiction, and about removal, and then we'll move on. And okay, yeah, let's do that now. All right, I'm not going to spend a lot of time on removal. I think I'm going to just hit up some of the key points of it. Oh, I should probably quickly note, my bad, I should probably quickly note before we move on, Exxon versus Alipata. I shouldn't skip over that, my bad. So let's go back to supplemental for a second. All right, Exxon versus Alipata deals with the following problem. Look at this clause down here. Claims by persons proposed to be joined as plaintiff under Rule 19. All right? Note that there's no mention there of Rules 20 or 23. There's nothing mentioned there right here about 20 or 23. Now imagine you have two plaintiffs. You have, say, Florida and Florida versus California. Based on the plain language, there's no divestment under B. So imagine you have Florida versus California for 100K, Florida versus California for 10K. Let's assume it's the common nucleus of operative fact, so A would grant. Does B divest on its face? And on its face, the answer is no, all right? Even though original jurisdiction is premised solely on diversity, that says 100K. I know it looks like 100 IC, that should be a K. Even though OJ's solely diversity, and even though this claim's by a plaintiff, this right here doesn't fall into any of the joinder scenarios in those laundry lists. This is not a claim by a plaintiff against somebody joined under Rules 14, 19, 20, or 24. Why? Because there's only one defendant. You use these rules to bring in more people or additional people, right? This is a sole defendant. This is not a Rule 19 defendant. It's the only defendant. It's not a Rule 20 defendant because there aren't multiple. It's not a third-party defendant. See where I'm going? It's not a P versus a 14, 19, 20, or 24. And this is not a claim by somebody, by a plaintiff under Rule 19 or a plaintiff under Rule 24. This is actually a claim by a plaintiff joined under Rule 20. Remember, Rule 20 permits joinder of multiple plaintiffs or multiple defendants. Now, if the statute said here, claims by persons joined as plaintiffs under Rule 19, 20, or 23, then B would divest this, because this is a claim by a Rule 20 plaintiff against a single defendant. But the statute doesn't say that. That's what happened in Exxon versus Alipata. This is important. If you see a scenario where there's one defendant but multiple plaintiffs, then you have an Alipata scenario. And what the court said is that 1367B does not divest jurisdiction in this scenario. There's nothing in those laundry lists that divests a claim by a second Rule 20 plaintiff against a single defendant. The court nonetheless noted about the contamination rule. And we're going to note that briefly, and then we can move on. What if you had Florida and Florida, 100K versus California, and my bad, that shouldn't be Florida. Here we go. Let's even make it 100K. All right. Here we have original jurisdiction, right? Here we don't have original jurisdiction, right? Let's assume common nucleus of operative fact. You think A would grant supplemental jurisdiction, right? The Supreme Court said that you can't do this at all. Now let's go back to basics. 1332 wouldn't allow this at all, would it? Do we have complete diversity? No. And what the Supreme Court said in this scenario, the addition of the non-diverse plaintiff would destroy the original jurisdiction that's required to have supplemental jurisdiction. You go back to basics here. What do you need to have sprinkles? You need ice cream, right? What do you need to have supplemental jurisdiction? Original. What happens to original jurisdiction if you destroy complete diversity? It goes away, right? So in this scenario, the presence of California contaminates the 1332 original jurisdiction up here, and there's no jurisdiction at all, right? And what the court says here is kind of weird and dumb, because the big difference between these two is here the defect is amount in controversy, right? The parties are diverse, but the defect's amount in controversy. Down here, the amount of controversy is met, but the parties aren't diverse. Supreme Court said, and you can agree with it, you can disagree with it, but you got to know it. This does not destroy the original jurisdiction of diversity. This does. Write it down, know it. Very testable. Very easily turned into a multiple choice question. All right, now we move into removal. All right, some comments on removal. First, when you remove, you don't remove a single claim, you remove the entire case. Removal is one way. It's meant to take a civil action, lock, stock, and barrel, from state court to federal court. Removal goes from the state court to the federal court. If there's a problem with removal and it has to go back down, then the case is remanded. Back down from whence it came, from federal back down to state. All defendants who have been served must consent to the removal. So if P sues D1, D2, and D3, and only 2 of them want to be in federal court, then removal cannot be done. removal would be improper. Removal is not a basis for original jurisdiction. In order for removal to be proper for purposes of SMJ, there has to be subject matter jurisdiction under some other basis, which require either all original jurisdiction or original jurisdiction combined with proper supplemental jurisdiction. Okay? So removal by itself is not a basis for jurisdiction. It is instead a means, a vehicle from going from state court to federal court. Next issue, venue in a removal case. The venue for a removed civil action is not measured by the venue statute, 1391. Remember, 1391 will look to where parties reside, or stuff happened, blah, blah. The proper venue for a removed civil action would be the federal court that corresponds to the location of the state court from whence the claim was removed. So if we remove a case from Miami-Dade Court to federal court, the proper venue is going to be the U.S. District Court, Southern District of Florida, without reference to 1391. What else? In-state defendant rule. All right, so that's under 1441B, B2. It exists to prevent removal in cases that are premised solely in diversity and where any of the defendants are citizens of the state in which the action is brought. So in a removal scenario, and this again, extremely testable, look for a removal fact pattern where the sole basis for jurisdiction, for original jurisdiction, is 1332, diversity, specifically 1332A, and any of the parties is a citizen of the forum state. So, for example, California versus a citizen of Florida seeking $100,000 for a car accident, and it's filed in Dade County here in Florida. Well, if this case were to be removed, the removal would have been improper, right? Because of the in-state defendant rule. Why? Because the sole basis for OJ was diversity. And because at least one of the one of the defendants is a citizen of that state. In contrast, suppose the case was bought in was bought in Los Angeles, California, right? Well, if it's removed, it's being removed to the Central District of California. The basis for removal would be diversity, and removal would be proper because the defendant is not a citizen of the state of California. And this still works. Say you have Florida versus California and Pennsylvania, and the case is filed in Court of Common Pleas in Allegheny County, in Pittsburgh, PA. All right. Florida versus California and Pennsylvania. Well, assuming the sole basis for removal is diversity, right? The sole basis for original jurisdiction is diversity. Well, at least one of the defendants is a citizen of Pennsylvania, right? And therefore the case should not be removed. And if it is removed, then the defendant should seek remand on the basis of improper removal. Now, how about remand, right? Removal and remand, the timing and the specifics. Removal needs to be within 30 days of the defendant's being served, all right? Actually measured 30 days from the last defendant to be served. If the case as filed is not originally removable, then removal can take place up to 30 days after when the case initially becomes removable, all right? There's some additional twists on that I'm not going to get into that involve when the sole basis for removal is diversity and the case has been pending more than a year. This I want to refer you to in your books. If you have any questions, get to me. But I think I need to move on to some new topics. We're going to move on to personal jurisdiction in a few minutes. Remand. Remand. Suppose a case is removed and it was improperly removed. A violation, for example, of the timing. The defendant removed too late. All right? Well, a plaintiff can seek remand back to that state court from which it was removed. The normal timing for remand is up to 30 days after the removal, all right? So normally, a plaintiff has 30 days after removal to seek remand, unless the reason for remand is that the federal court lacks subject matter jurisdiction. And in that case, remand may be sought anytime through final judgment. Okay. All right, that's it for now on subject matter jurisdiction. I'm going to pause the tape. Thank you.